Hey there, I'm attorney Kelly Longtin from Kelly Longtin Law, where we focus exclusively on estate planning. And today I want to focus on athletes because it's your game is not the only thing that needs to have a winning strategy. Your estate plan does as well. In sports, success frequently brings significant monetary compensation. While this is a dream come true for most individuals, it's important to take the right steps to safeguard this hard earned money. Now, most people assume that the biggest challenge is spending beyond one's means. While this can cause many problems, it is not the only issue that athletes need to be aware of and to plan for. So, athletes, there's one type of penalty that I want to talk to you guys about, and that's taxes. Now, there's several types of taxes that may impact you as an athlete if you play sports in the United States. The first type of tax I want to talk to you is the gift tax. Now, as you make more money, it's natural to want to give it gifts or to support your loved ones. But I want you to be careful as those gifts could generate a tax. According to the IRS, the gift tax is a tax on the transfer of property from one person to another when nothing or less than full value is received in return. Now, luckily, not all gifts are subject to this tax. Each person has an annual gift tax exclusion of $15,000. This cap is the amount or value that someone can give another person during the calendar year without the IRS assessing the gift tax. This amount is per person, meaning that you can give up to $15,000 to as many people as you want. An easy way to avoid the gift tax is to make sure that you're not giving a friend or a loved one more than the annual exclusion amount each year. The second type of tax that you athletes need to worry about is income tax. So depending on your team's location, it is quite possible that you permanently reside in one state but play for a team in another state or even another country. Because you're earning income in one state or country, but you're residing in another, you may owe taxes in both jurisdictions. Now, it's important that you work with an experienced tax professional to make sure that you're paying the right income taxes at the right time. The last thing you want is to owe more because of penalties and interest. And next, I want to talk to you about estate tax. Although estate tax is not assessed until you die, it is vital to think about it now. As previously mentioned, the lifetime estate and gift tax exclusion is currently high, but that is going to sunset. Because no one has a crystal ball to determine when you're going to die and what the estate tax exclusion will be at that time, we always need to be very mindful. Given your career as an athlete, your income potential is great and will most likely come in large lump sums. Invested properly, those large lump sums can grow even larger. So you want to talk about guarding your money and property. And as a high earning individual, your first line of defense is having the proper insurance. This includes homeowners, automobile, long-term, disability, and life insurance. In the event that money is needed to pay a claim or to satisfy a judgment, these policies will be available first before looking at the rest of your money and property. You should periodically review these policies with an experienced insurance professional to ensure that you are adequately covered. As your income increases, so should the amount of your life insurance. As you acquire more accounts and property, you should also adjust your other policies' values to reflect these increases. As a further step, there are sophisticated asset protection tools that we can use to provide you with more protection. Some states do a domestic asset protection trust, which is a type of an irrevocable trust, in which you, in your role as the grantor, the trust maker, permanently gift your accounts and properties such as your home or cash or stocks or other investments. And once it's transferred into this type of trust, the accounts and property are legally protected from future lawsuits and divorcing spouses and bankruptcies and similar threats. The trustee, the person or the entity that you've chosen to manage or invest or use the accounts and property, they can then make distributions to you as the grantor, thereby allowing you to continue enjoying some of the benefits of the property in the trust. In most cases, the trustee must be an independent trustee, someone who is not related or subordinate to you, or any other beneficiary, and will not inherit anything from the trust to preserve the trust asset's protection nature. It's important to remember that these domestic asset protection trust laws can vary significantly by state. Residency requirements for the grantor or the trustee of these types of trusts vary from state to state, as does the required connection to the grantor with these domestic asset protection trust states. It is crucial that you work with an experienced attorney when you're designing these types of trusts to make sure that it's not considered a fraudulent transfer meant to defraud an existing creditor, which could really land you in some hot water. And keep in mind, in some states, these trusts aren't even a viable strategy for you. Another valuable strategy which protects the financial well-being of your loved ones is an irrevocable life insurance trust. An ILIT is an irrevocable trust created by transferring an existing life insurance policy into the trust or by the trust purchasing a new policy. Using your annual gift tax exclusion, you can make cash gifts to the trust in order to pay the premiums on the insurance policy. Upon your death, the death benefit is paid to the trust, and the money is distributed according to the instructions that you left in the trust documents. Not only does this strategy allow you to utilize your annual gift tax exclusion and remove the value of the life insurance policy and death benefit from your estate, but it also allows you to direct and protect the money you're leaving for your surviving loved ones. You can use an ILIT to provide cash to your loved ones without increasing the value of your accounts and property that is subject to that estate tax. Let's talk about what happens if you can't manage your money or your property. While you may currently manage your money and property yourself or with a professional's help, have you even stopped to consider what would happen if you are unable to continue managing your money and your property? You might be injured on the job or afflicted with a condition that renders you incapacitated and unable to communicate or make these decisions for yourself. Or if you play for a team in a state or a country other than where you permanently reside, you may be out of town and unavailable to handle these necessary transactions. A revocable living trust is a trust that you create during your lifetime, and you can change it at any time prior to your incapacity or death. This planning tool enables you to name yourself as the current trustee, the person or the entity charged with managing and investing and handling out the money and property, and to designate a co-trustee or alternate trustee if you're unable to act as the trustee. A revocable living trust also allows you to continue enjoying the money and the property during your life and while you're incapacitated, as well as designate what will happen to that money and property upon your death, protecting it for your chosen beneficiaries. For this strategy to work as intended, however, any accounts or property meant to be owned by the trust must be properly funded into the trust. Funding the trust involves changing the ownership of the accounts or the pieces of property from yourself as an individual to yourself as the trustee of your trust. If the trust doesn't own a particular account or property, the trust terms will not control what actually happens to it. Lastly, not only does a revocable living trust allow for continued management of your account and property if you become unable to act for yourself, a properly funded revocable living trust also allows those accounts and property to avoid the probate process. This means that upon your incapacity or death, your financial matters can be handled privately by those that you've chosen, and the details will be kept out of court records and the media. One caveat, however, a revocable living trust will not protect your money and property from your creditors or judgments. An additional tool that can help manage your money and property is a financial power of attorney. This document allows you to choose a trusted person, your agent, to handle your financial matters on your behalf. Your agent can handle a wide variety of transactions, from signing the checks to opening a bank account, depending on the authority that you gave that person. If you wish your agent to act only in certain circumstances or transactions, then a limited financial power of attorney can be drafted for those specific circumstances. Alternatively, if you would like to grant your agent the authority to conduct all of the financial transactions that you would have been able to do for yourself, then you can certainly prepare a general financial power of attorney. Another consideration is when you want your agent to act. If you want to limit your agent's ability to act, A springing financial power of attorney allows your agent to step in only when a determination has been made that you are no longer able to handle your financial affairs. On the other hand, if you would like your agent to be able to act right away, an immediate financial power of attorney can be created. Even though your agent can act on your behalf as soon as the document is signed, it does not impact your ability to continue carrying on your business for yourself. Your agent is just an additional person who has the authority to act. This can be a very useful tool if you routinely travel for work. Lastly, if you want your agent to be able to act when you're no longer able to handle your affairs, it's important that the financial power of attorney be durable. This means that the document and your agent's authority will not be affected if you are later determined to be unable to make financial decisions for yourself. When the agent can act and what the agent can do are all things that can be customized to your unique situation. Due to the risk of injury that comes with such a physically demanding occupation, having proper healthcare documents is absolutely crucial. These include a durable medical financial power of attorney or medical power of attorney, a living will, or advance directives, and a HIPAA authorization form. A medical power of attorney allows you to name a trusted healthcare decision maker to communicate your medical wishes in the event that you are unable to do so. It's important that you name someone who will respect your wishes and carry them out when you are unable to communicate them to the appropriate medical professional. However, this person will only be able to make medical decisions on your behalf if you cannot. If you can make decisions and communicate them, then you remain in control. A living will or advance directive allows you to clearly convey your wishes regarding end-of-life decisions. Because these can be very sensitive topics, it's important that you carefully consider your wishes. This may take a little bit of soul searching, but it is necessary that you know what you would like to have happen in certain situations so that your wishes can be properly documented and communicated to your chosen medical decision maker. Absent specific instructions from you, your medical decision maker is going to be left trying to figure out what you would have wanted. This can cause additional grief in a difficult situation, as well as potential fighting amongst your loved ones. A HIPAA authorization form allows you to grant certain individuals access to your medical information. For example, to get a status update on your condition or receive your test results, without giving those individuals the authority to make any decisions on your behalf. By at least providing the medical information to your loved ones, you can help quiet the anxieties and uncertainties that often arise during these times of emergency. This can also help alleviate tensions between your medical decision maker and the rest of your loved ones. Although only one person will be making the decisions, the rest of your loved ones will at least understand why these decisions were made. Proper estate planning is a must for everyone, but especially for you as an athlete. Not only do you have to address and manage tax, asset protection, and other financial concerns, you also need to protect yourself and your family in the event that you're injured on the job. Now, we always welcome the opportunity to work with you and other financial professionals on your team to help make sure that we have a winning game plan that will help you and have you and your family in the best situation that they can possibly be in. So if you have any questions, feel free to reach out to us, info@kellylongtinlaw.com. And just if you want to learn more information, you can follow our other videos as well. So I look forward to meeting you at some point. Attorney Kelly Longtin from Kelly Longtin Law.